Welcome to the second lecture of 12 this morning on intellectual property. I wanted to cover a few discrete subjects. A lot of the lecture materials are, I'm sure, up online, and I just want to sort of hit the high points. I'm not going to follow any real structure. If you want structure and if you want to memorize things, you can always go to the website. I'd like to just talk about things that are more interesting here. It's sort of like hit the highlights and sort of tailor my talks with you on what interests you more than having to follow a rigorous sort of outline. So, but what I wanted to cover this morning were a couple of very general concepts that I know each of you have heard about, but maybe not have clarity on. One is what is actually protectable, and in that I want to cover the difference between ideas and expression. I also wanted to cover the public domain, because I'm sure you've heard about that, but you may not know what it is, but it certainly affects you folks as students. And then I want to cover, how long intellectual property rights last. If you copyright or patent or trademark something, how long do those rights last? And I want to then finally cover fair use, because Professor Eager had talked about fair use, and again, that's something that really is going to be something that you're going to want to know about as students. So anyhow, let's talk about what can be protected, and this cuts across all forms of intellectual property. We talked about intellectual property, there being patents, trademarks, copyrights. A fourth form of intellectual property I would include is trade secrets. Anybody here ever have CocaCola before? All right. I can teach a whole course on intellectual property just using a CocaCola bottle. They are the most amazing owners of intellectual property. They have patents, they have utility patents, design patents, they have trademarks, they have copyrights. They also have a trade secret, which is the formula for Coca-Cola. The formula for Coca-Cola is kept on a piece of paper in a vault at their headquarters in Atlanta, and only certain executives of the corporation have access to that formula. It truly is a trade secret. And so trade secret is another form of intellectual property. Can a formula for Coca-Cola be protected in any other way? The answer is generally no, because it's mostly sugar and other stuff. Recipes generally can't be protected as intellectual property. Has anybody ever had a chocolate chip cookie? Well, there's no such thing as a patent on a chocolate chip cookie. A chocolate chip cookie is a cookie with chocolate chips in it. The only way you can patent a recipe is if there's something about the recipe that does something unique, like extends the shelf life of the material or makes it easier to make. But when you're talking about basic ingredients like chocolate and cookie dough or carbonated water and sugar, those things aren't protectable. But if you have a particular recipe that isn't subject to intellectual property rights in any other way, you treat it as a trade secret, then it's considered intellectual property. But you have to treat it like a trade secret. You have to keep it in a vault. You can't publish it. You can't tell people about it. You really have to treat it as a trade secret. So trade secrets are like the fourth form of intellectual property. So in order to protect intellectual property, whether it's a trade secret or whether it's a patent or a copyright or a trademark, you have to express it. You have a question, I'm sorry.
And these people are coming up with new algorithms to do these sorts of things, and they can be applied in a broad space. Can they patent the algorithm itself? Do they have to patent its specific application in a space, or use in a software?
I'm going to give you an answer that basically is the correct answer to any legal question. It depends. But you bring up a very interesting concept, and we'll get into it a little bit better a little bit later on once I cover some of the basics. But there are ways of, there's a concept called overlapping protection. So something like an algorithm can be copyrighted, but it also can be patented if it's original and it does a particular thing. Let's say you come up with an algorithm that can trade something on the stock exchange at a half a second faster than any other algorithm, meaning you make 1 penny per half second faster than anybody else. That sort of methodology can be patented. If you write it down in a book and publish it, it can be copyrighted. It can be copyrighted just like software. But the one thing you have to do, okay, in order to get any sort of protection, whether it's patent, copyright, or some sort of overlapping protection, is it has to be expressed in a tangible form. There is no intellectual property protection for ideas. So if you think of a better mousetrap or a better algorithm, and you keep it to yourself, you own nothing except a very good idea. In order to protect it, it must be expressed in a tangible form. Examples of things that, and here's the statute, the Copyright Act of 1976 is very specific about this. It says, in no case does copyright protection extend for an original work of authorship, extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. Okay? So ideas, unless they're expressed in a fixed form, aren't protectable. Now, getting back to your question, what constitutes a fixed form? Well, Mozart, when he took his quill pen and wrote on a piece of parchment the score to his music, once that piece of paper touched the parchment, the idea is being expressed in a tangible form. And that's an easy one to conceptualize. When you print a book, when you have the idea in your head, it's not protectable, but when you reduce it to writing, it's protectable. Because it's expressed in a tangible form. When you are thinking of an algorithm in your head, or you're writing you have an idea for writing software in your head and you're writing on your computer. When it's on the screen, it's not fixed in a tangible form. When you hit save and it goes into a ROM memory, read-only memory, or some other memory device, it's fixed and tangible. Now there's all kinds of things. You mentioned machine learning, and we've talked about, we haven't talked about it yet, but we've mapped the human genome. We can actually, there are ways that people who are paralyzed can express thoughts through machines. So when they express the thought, it's still not fixed, but when it appears on the screen of the computer and is subject to storage, it can be saved. I would say that that's fixed in a tangible form. All of these concepts I'm talking to you about, I may use some really loony examples, literally, to teach these concepts. This is why I say I can teach a whole class in intellectual property using a Coke bottle. Because all of these concepts are the same. And whether it's an algorithm or a Coke bottle or a composition by Mozart or the Gideon Bible, all of these things have to satisfy the same conditions in order to qualify as protected intellectual property rights. So the most irreducible form of intellectual property protection qualities is that it must be expressed in a fixed form. Ideas are not protected. As soon as you express the idea in some fixed, tangible form, it's protected. Now the interesting thing is it's protected the minute that you express it. So when you for instance, compose a Broadway musical and you put the score down on a piece of paper, you don't have to register that in order for it to be protected. There's a whole system of federal registry. The United States Patent and Trademark Office registers trademarks, registers copyrights, registers patents. You have the intellectual property rights to that invention so long as it's expressed in fixed form, whether or not it's registered. The only reason people register these things is because they want to protect the rights from infringement, and it's easier. You have presumptive ownership rights when you've registered it. It's a lot. In the old days, you used to have to prove these things the hard way. You used to have notebooks and other ways of showing that you'd express this idea in tangible form. So the system of registration that we have is there as a convenience to the inventors or the owners in order to prevent infringement. But as soon as the idea is expressed in tangible form, you own it, okay? And that's a common law right that you have. That predates all of the federal regulation, that predates everything. You have a common law right to that, so long as it's expressed in tangible form. So a paper describing a political theory, for example, is copyrightable. But the theory is not. Marxism, communism, socialism, those are concepts that aren't protectable. But if you write a book about them, those things are copyrightable. A business method, efficiency, inefficiency, assembly line, those things are not copyrightable or protectable under patent or trademarks. But if you describe a business method and you have some originality that you add to it, it very likely could be protected. Scientific theories are not protectable. I'll give you some examples of things that are not protectable. Systems of measurement, 12 inches equals a foot. Tools used to measure things such as rulers, mathematical principles and theorems, scientific discoveries, gravity. You can't patent gravity. Business procedures, efficiency. Phone books, directories, and things that are in the public domain. Yes?
So I guess I'm a little bit confused about, I'll explain. So over IAP, I was working at a cosmetics company, and it's like something like a technology that came out of one of Bob Lager's labs. And while I was there, it happened to be the case that some mom and pop shop made up the same or a very similar technology. It's like an under-eye wrinkle cream, and my whole team was trying to figure out can we sue them for patent infringement? Mm-hmm. But I guess if it's a slightly different formulation, but it has the same kind of wording and the same processes, and I guess I was also thinking about it in code. If you have the code to make to trade stocks 1 millisecond faster or whatever it is, and someone else makes slightly different code, they write it slightly differently, but it does the same thing. Where's the how can you tell whether that's infringement?
Does anybody know the answer to that question? It depends. It depends. I'm sorry, but it depends. There is an originality requirement in order for something to be protected, okay? So, and that comes right out of the statute, right out of the Constitution. The originality requirement, though, is kind of a subjective concept. Have you added enough of this to create distance between you and the prior art, it's called, in order to qualify for protection? Now, if your cosmetic was granted a patent by the United States Patent and Trademark Office, somebody down there decided, well, this development in this cream was sufficiently unique and original as to distinguish it from prior art, the cold creams and anti-wrinkle creams that everybody had done before, that it's eligible for protection. In which case, if somebody comes along and is using the same process or the same things and has not added anything and is not using a demonstrably different method or formula, then they're probably infringing, okay? The way it's decided is called the reasonable man standard, you know? That's literally how these cases are decided. You go in front of a jury and you have experts testify. One side will say, oh no, this is not an infringement because it's completely different than what they thought of. And then you'll hire experts that will say, no, it's exactly the same because it's based upon, you know, it's derivative of our formula. An example is the CRISPR litigation that has been going on. You know, one side says, you know, this is brand new, it's a new application, especially for humans, and the other side said, well, we hadn't proven it, but it's derivative. Of course, the people at the Broad Center won, you know. So they were able to show that it was there was daylight between it and the prior art. They had, in fact, it was helped by the fact that the scientists for Stanford and University of California all went on media and started saying what their gene editing technique could not do. Then the Broad went out and did it, and they used the interviews that the scientists gave about the limits of their invention against them later on when they said that they should be covered and that Broad was infringing. So it really has to do with whether or not your invention has created any daylight between the prior art that you're being accused of infringing on. So the answer is, it depends, okay? So the legal term public domain refers to anything that doesn't have intellectual property protection. So for instance, if the patent has expired on your invention after 20 years, it goes into the public domain. If the copyright has expired on your work of art after you die and 70 years have gone by, which is the life of a copyright, it goes into the public domain. If you don't maintain your trademark, if you fail to use it in commerce for a period of time, usually about 5 years, it will be considered abandoned and the trademark goes into the public domain. Things that aren't entitled to protection anyway, like systems of measurement, scientific discoveries, gravity, by the way, is in the public domain. Concepts that are more akin to mathematical formula or scientific discoveries, those are all, we own all those things. That's what the public domain is. Anything that the government has paid for is in the public domain. You can't, as a student at MIT, work in a class that is funded by Office of Naval Research and expect to own the inventions that you come up with. The government owns those. The taxpayers paid for it, so the taxpayers own it. Under certain agreements, you can get a portion of the royalties as a reward for your ingenuity. But since you were using government funds, in most cases, those inventions are in the public domain. Look at the space program. I mean, all of that was funded by the government. That's why we have the internet. That's why we have, computer chips. That's why you have a cell phone. All of that technology funded by the government went into the public domain and then was used by companies like Microsoft and Apple and, Samsung. But the original technology was all the result of government funding. And that is in the public domain. So those are some examples of the public domain. Some French poet by the name of Alfred de Vigny equated the expiration of a copyright with a work falling into the sinkhole of the public domain. It's a little bit of a pejorative, but it really is the vast amount of information and inventions that we, the public, own as a result of the fact that we've either funded it or because the rights that the inventor originally had or the author originally had have expired. So some examples of things that are in the public domain: the works of Shakespeare, Mozart, silent films. Most of the films that were produced prior to the 1930s are all the copyrights have all expired, so they're in the public domain. Newtonian physics, thermodynamics, those are things that never were protectable. And of course, any software written before 1974, the 1976 Copyright Act makes that a fact. So if the software was written before 1974, it's in the public domain. You can then take it and improve it, not worry about having an infringing on some authors or some software writers' intellectual property rights. And so all of these things are examples of the public domain. Does anybody go home at Christmas time and watch the movie It's a Wonderful Life? I mean, that movie was, I think, filmed in 1934, but because they forgot to comply with the law for a long period of time, that movie fell into the public domain, and TBS and all it used to be on ubiquitously. I mean, it was on every channel because every television station could show it without having to pay any royalties. And then Warner came along one day and were able to reestablish their ownership to the thing because to the movie because they proved that the movie was a derivative act of another story that they actually own the copyright rights to. But for a long time, the movie It's a Wonderful Life, which everybody is familiar with, was in the public domain. But it's now back owned by Warner's for, I think, till 2030, when the rights will expire again. Yes, sir?
How often do they change the length of the patent or the copyright term? It used to be like 14, now it's 20. Isn't it usually like when the one for Mickey Mouse is up, Disney petitions the government to make it extended?
Well, there are ways of, we talked about overlapping protection, and I talked briefly about things being derivative. So there are ways of, without changing the law, or of taking advantage of parts of the law in order that provide for overlapping protections to extend these things. So yeah, basically, but you're also correct, I think, that every time the Congress gets together and writes a new copyright law, an awful lot of lobbyists paid by Disney and other entities petition them for for extensions of time. And you're correct. The old Copyright Act before 1976 was 28 years. You could get extended a second 28 years, but it was 28 years. 1976, they passed the act, which gives copyright, it's the life of the author plus 70 years, or 69 years, whatever it is. But, so every time Congress changes the law, they redo this balancing test. And the balancing test that they're doing is, what are the rights of the owners, the authors, and what are the rights or the interests of the public? We want to reward people for their inventiveness. It costs a lot of money to bring a drug onto the market. It costs a lot of money to produce a movie, And so, we want there to be incentives for people, profit incentives for people, and so we're going to protect them for a given period of time. But then again, we also have the interest of the public to this information, this knowledge, and the sharing of that knowledge, because society is bettered by that. So these years, 20 years for a patent, 15 years for a design patent, 70 years for a copyright, 10 years for a trademark, these are all arbitrary numbers. They didn't come from somebody. They were just thought up. And it's the result of this balancing test that Congress does periodically in response to, the intense lobbying that goes on. Has anybody ever sung this song? All right, you're all familiar with it. If I were to sing that song right now, would I be violating a trademark or a copyright? And the answer, of course, to that is it depends. In this case, it depends on when you ask the question. Because up until a few years ago, I don't know if when you were kids you went to Chuck E. Cheese or Papagino's and they forced all the help to come around and sing to you, that they had to pay a licensing fee to Warner's. And the guys from Warner's with their little briefcase and their gray suits would come out to Chuck E. Cheese and they'd come out to Papagino's, and they'd monitor these things, and they'd send them a bill. It was usually $200 to sing Happy Birthday. But in some cases, it was $1,500. In other cases, it was $5,000. The story of the story of the life of Martin Luther King had a scene in it where they sang Happy Birthday to him. But it never made it into the final DVD because the authors and the publishers could not afford the $5,000 fee to Warner's that it would have required them to pay if they had included that scene in the life of Martin Luther King. So what happened is Happy Birthday goes back to Patty Hill and her sister Mildred, who were teachers back in the 1890s, and they used to greet their students every morning with a song called Good Morning to You. And it was Good Morning to You. Any of you, the Sisters of Charity of Nazareth, who educated me in the first 10 years of my academic life, used to sing that damn song to me to us every morning. It goes back to 1893. I'm not that old, but the song goes back to 1893. Mildred and Patty were the composers of Good Morning to You. But then they began to sing it in association with birthday parties. And it didn't take long for the song to become popular, and it ended up on the radio, and it ended up, in musicals and things like that. And their third sister, Jennifer, Jessica, I think, who was the smart one, decided that she would copyright the song Happy Birthday to You that her sisters had sort of popularized. And so she went to the she hired a lawyer, went to the USPTO, and she copyrighted it. And the next thing you know, a company called Sumi acquired the rights for several millions of dollars in 1935. And Sumi went out and registered it under their name. And under the licensing agreement that they had with Mildred and Patty and Jessica, they would get royalties until they died. But they paid them a large amount of money and then registered the copyright. And then it was these guys who then eventually sold it to Warner in 1988. And it was Warner that made millions off the song. And they were the ones that literally went out to Chuck E. Cheese and McDonald's, wherever they were singing Happy Birthday, and they were charging people. They would charge the producers of the Martin Luther King movie. They were charging, if you had a scene in a movie or in a Broadway show where they sang Happy Birthday, you'd get a bill. And Warner's made, when they purchased the company for $25 million, and they purchased it for one reason, because they owned the Happy Birthday song. They had estimated the value at that time at $5 million, which in today's dollars is much more. And Warner's went out and charged millions in fees. In fact, about $15.5 million until they ran into Jennifer Nelson, who was a film producer in California, and she wanted to do a movie or a documentary about the song Happy Birthday. And they came to her and they charged her $1,500 to do a movie about their song. And she said no. And she brought an action against them. It's called a cancellation action. And she won because she was able to establish that Happy Birthday was already in the public domain when it was mistakenly copyrighted by the United States Patent and Trademark Office. What she was able to show is that Mildred and Jessica and Patty really didn't own this song, that this was just sort of a compilation of things that were in the public domain, and that they never should have received a copyright on it from the United States Copyright Office. So since they didn't own the copyright to it, they had nothing to sell to Sumi, and Sumi had nothing to sell to Warner Brothers, and so Warner Brothers got nothing for their $25 million, and they had to take the $15 million that they had charged Chuck E. Cheese and people like you and me and the producers of the Martin Luther King documentary and everybody else and give it back. So to me, Jennifer Nelson is a hero because she wouldn't take it. Yes.
Is that, like, could Warner's do anything to, like, sue me for, like, selling them, selling them something that they thought was worth so much that
Yes,
it was worthless?
absolutely. Except Sumi didn't have any money. Sumi can then turn around and sue, Mildred and Jessica, but they don't have any money. So it's kind of like a game of musical chairs. The one that, when the music stops, literally, you're the one holding the bag. And that's what Warner Brothers ended up holding the bag. Yes?
So, but when a larger company acquires a smaller company, and something like this happens, or maybe the smaller company has a technology that you think is breakthrough, but really is not, at what point do you just say to the big company, like, hey, you should have done your due diligence? You didn't do due diligence, so... Yeah,
well, it depends on the context, but obviously, if you're involved in a patent infringement case, like, Jennifer was, that's when you say it. I'm sorry, but I disagree. You should have done your due diligence. And Warner is there saying, but we paid $25 million. We don't care. You didn't do your due diligence. You should have hired lawyers to take a look at this and see whether or not Mildred and Jessica and all the others, had the rights, had any rights that they could convey. Let me tell you, they're represented by the best lawyers in the world, and they spent a lot of money on that litigation. And Jennifer was, she had to collect money from other movie producers in order to, fund the litigation. She appeared essentially pro se. So she, it was David and Goliath. And in this case, David won. And the reason is, it doesn't matter how big you are, if it's not subject to intellectual property protection, if it doesn't qualify as having been expressed in tangible form, or if it doesn't have the originality requirement, if it's already in the public domain, then you don't own anything. You don't have anything that's protectable. Okay, so, and like I said, these are stupid examples, but they illustrate the concept. So whether we're talking about Happy Birthday or a Coke bottle or the trademark for Looney Tunes or an algorithm or some sophisticated piece of software, there's no difference between software and a Coke bottle, software and Happy Birthday. I just choose Happy Birthday because it puts a smile on some people's faces. It's a little more fun to learn it that way. But it's no difference. No difference. It's like the difference between a little house and a mansion. They're both, fixed in tangible form. They're subject to ownership. And they, if they have four walls and, a roof, that's it. It doesn't matter whether it's a big house or a little house, or whether it's software or if it's just some kind of drawing. All right, so how long do intellectual property rights last? We've already sort of hit on this. I'll just give it to you. Trademarks, 20 years. Can you apply sometimes for extensions? Yes. Did I say trademarks? I misspoke. Patents, 20 years. Now, sometimes you can apply for extensions. Oftentimes, so the way the USPTO does it is they go back to the original filing date. And sometimes when you're bringing a product to market, you can spend 15 years bringing that product to market. Think of drugs that take a decade of clinical trials. In order to recover, you need sometimes to extend. And there are provisions under the patent laws that extend patents for in certain circumstances. Okay? But generally, a patent is 20 years. So the United States Patent and Trademark Office doesn't calculate, so they don't send you a letter when your patent is expired, but they do have online a calculator that you can use to estimate the expiration dates of utility, plant, or design patents. And what you do is you put in the date of original filing and the type of patent it is, and the calculator will give you its estimated. So that, and that's necessary because when you are licensing that technology to another company, you need to be able to disclose to them what they're buying. Mildred and Jessica didn't do this, but of course the calculator wasn't around back then. But that would have been helpful with Happy Birthday. A design patent is a little bit different. It's a form of intellectual property protection which allows an inventor to protect the original shape of something. Okay, so it's different than a utility patent. Example of a utility patent is a mousetrap, okay? Something that catches mice, something that does something. In the Constitution, it's called a useful article. So if it's a useful article, if it does something, it's a utility patent. But there's also things called a design patent, and that doesn't necessarily do anything, but it looks like something that does something, okay? So you can have both a utility patent on something and a design patent on something. Examples of a design patent. Does anybody know what that is? Yeah, it's a Coca-Cola ball. It's very distinctive. You know, this thing has been around for an awful long time. It really has become iconic. The reason you can say that this is a Coca-Cola bottle is because you've become familiar with it. It's something that is, it's iconic. But not only is this a design patent, but it's also a utility patent. Because this is designed to hold a carbonated beverage in a certain way. Now, you asked about how you extend these things, okay? So your Coca-Cola, it's 1920, you have a utility patent on this, and now it's 1940 and your patent is about to expire. What do? Exactly. You change it. You put another groove in it. You extend the neck, you shorten the neck, you make the mouth a little wider, and you file another patent application, and then you're off for another 20 years. And that's what Coca-Cola has done. They just change it, they just tweak the design, and they come up with some rationale for doing it, and they extend it that way. Yes, sir?
So if you're the owner of the patent, can you tweak it by a smaller amount and file a new one compared to a competitor? Like, could a competitor come in and add one extra groove and have theirs be different? Or then is that, since they're different companies, is that more infringement than you as the original owner?
The answer is somebody could come in and do that, but the litigation would be furious, you know? And there's kind of like this thing. Pepsi doesn't mess with Coca-Cola. Coca-Cola doesn't mess with Pepsi. You know, there's this sort of ethic out there. But theoretically, could you come in when this patent is about to expire and come up with a design which is slightly different? Yeah, sure. And then Coca-Cola would be having to license it from you. But knowing what I know about Coca-Cola, you're better off trying to think of some other way to game the system because they are on these things and they have rooms full of designers that just come up with slight tweaks. There was another question? Same question. A design you might be a little bit more familiar with. Anybody own an iPad? So the design of an iPad, or a, what do you call that thing? I own one of those. Yeah, right. That's not only a utility patented device, but it's also a design patent device. So you can't go out and design a music player that looks exactly like this, because Apple has obtained trademark protection for both the two-dimensional shapes of the iPod and for the three-dimensional shape of its iPod. And they're filing more. Every time they come out with a new design, next week or next lecture I'll bring in an Apple bag. An Apple bag, you know, it's like a Coca-Cola bottle. I can teach a whole class in intellectual property just based upon the patents that are in an Apple bag, or bag. And I'll bring it in and I'll show you. And we'll talk about how many different types of intellectual property are represented by just an Apple bag. So design patents, this is the section of the statute. And they go for 15 years. So a utility patent is 20, a design patent is 15 years. Why? I have no idea. But if you're Coca-Cola, the best thing to do is to have a utility patent and a design patent because the utility patent lasts longer. That's called overlapping protection. So what is a copyright? This is the third form that we haven't really talked that much about. And it's just that body of exclusive rights granted by law to authors of original acts. Okay? That includes anything. A story, a song, computer code. Anything that can be written down or can be recorded in electronic memory is subject to copyright, as long as it meets the two threshold requirements of originality and being expressed in a fixed or tangible form. Okay? Ideas or not. And copyright literally means the right to copy. And it's a form of protection that, like the others, is governed by US law, and it extends to things like literary, dramatic, musical, architectural, calligraphic, choreographic, pantomimic, pictorial, graphic, sculptural, and audiovisual creations. This comes from the statute. So when you go to the ballet and they say no pictures, the reason why they say that is because they're protecting their copyrightable performance. When you go to the movies, you can't sit there with a recorder and record what you're seeing because it's copyrighted. It doesn't belong, it belongs to the authors. You don't have the right to copyright it. It's somebody else's original work. Here's an example of a copyright. This is also an example of a trademark, okay? Going back to extensions, your Warner Brothers, you have a copyright on this. I think this goes back to like the late 1920s. Pretty soon, or if they haven't expired already, the rights to this will change, will expire, it will go into the public domain. What do? Two things. You can change it, right? The other thing you can do is you can trademark it. A trademark is basically forever. If you register a trademark, so long as you continue to use the mark in commerce and file an affidavit with the United States Patent and Trademark Office every 5 years that you're using it in commerce and provide them with exemplars, the trademark continues for as long as you use it in commerce. So this is infinite protection. Again, an example of overlapping protection. One of the things that Coca-Cola does with its Coca-Cola formula, Coca-Cola logo, is they trademark it. That logo, even though the patent expires, even though copyright expired, trademark is forever. Yes, sir?
Using e-commerce, does it mean that if I just produce maybe one piece and sell it online for, try to sell it online for $100,000, is it still considered as a proof that I'm trying to sell my product? So
using that example, I would say that's very clearly use in commerce. Okay, all you have to do is print up some brochures and send them out. It doesn't matter that you haven't even sold one yet. The fact that it's being offered for sale, I think, is sufficient to qualify for use in commerce. Okay, and they have examples of things where they sold 2 items at 50 cents a piece, and that was considered sufficient to satisfy the use in commerce requirement. So as long as you have it out there, I think that if you put a picture of it up on a telephone pole and you stick it up there for the public to see, offering it for sale, I think that's sufficient use in commerce to qualify for trademark protection or continued trademark protection. Yes, sir?
How long before it's considered abandoned?
The general rule is 5 years. Again, the answer is it depends. But in litigation like this that I've done, the cases generally come down on around 5 years. So if you have a product for sale and you just haven't been paying attention to it for 2 or 3 years, I'd be concerned. But if you go for more than 4, or if you go out as far as 5 years, I think that it will be considered abandoned. And if you try to use it again and somebody has appropriated it, you could be the one infringing. So the idea is to keep using it in public, in commerce, even if it's just to advertise it for sale in a newspaper or on the internet. Yes.
Does your trademark hold for all industries or just the industry that you're selling?
Well, a trademark is based upon a particular use. So Coca-Cola would be considered applying to the soft drink industry or any other products that Coca-Cola makes. I'm sure they make, if they went into the cosmetic business, for instance, it would apply to them, to that as well. But the idea of trademark, the concept that a trademark is meant to prevent is confusion. So if I did, I don't know, Coca-Cola Law Office, I suppose I could do that because I'm not competing with Coca-Cola. I'm sure I'd get a cease and desist letter, and I'm not sure I'd want to spend a lot of money defending that case. But theoretically, I don't think that their trademark protection would extend to the law business. And there are better examples of that, like McDonald's hardware, McDonald's diner, Old McDonald's farm, okay? Now McDonald's and companies like Adidas and, what's the company up in Washington, Nike, they're very aggressive at enforcing. Tesla, for instance, came up with a logo that had 3 stripes next to a slash. Adidas successfully sued them because it had the 3 hash marks. And I'm like, well, actually what Tesla did is they gave up. They didn't fight it. But so some of these companies are very aggressive when it comes to enforcing these things. All right, let me just talk a couple of things. Well, how do you know if it's protected? Well, sometimes it carries these signs. In the old days, you used to actually have to have the word trademark in it, but under the new copyright law starting in 1976, you don't have to do that. I think this is an example of a trademark from the 40s. Back in those days, you used to have to actually put a mark on it. But nowadays, you don't have to put any marks on it. I think if you look at a book sometimes, it'll say copyrighted in there and it'll have a number, but you really don't have to do that. As soon as it's expressed in a fixed or tangible form, the copyrights attach. So they're protectable from that instant on. There are none of these formality requirements exist anymore. But a lot of companies that own these things put them on there just so that they can make the public aware that the material is subject to copyright. But is it necessary? No. It just helps. So I wanted to talk about fair use. So what is protected by copyright? Anything that is original and unique to you. Yes?
So sometimes I see on people's personal websites or their PowerPoint slides, they put a little C with a circle around it.
Yeah.
Can you just do that? Saying hey, this is just to reiterate to people, this is my...
Don did that to all of his slides day before yesterday. I saw the little, I don't know, whatever it was. Probably some lawyer told him to do it. Is it necessary to do? No. May you do it? Of course. If it's your original work, you have the right to do that. All these things I'm showing you, they belong to me. Okay? Do I bother putting a little C on there? I probably should, but I don't. Because I don't care if you steal it. I'll just go up and make up some better ones. But when I put these slides together that came out of my head, as soon as the slide was put on the memory of this computer, I own it. And whether it has a little C or it says copyright strictly enforced on it, doesn't matter, doesn't mean anything. So this brings us to the last concept I wanted to get to, which is fair use. But you know what? It's 9:56, and I want to spend about 10 minutes on it because it's so important to what you're going to do. But I'll just intro you to it. Fair use is a concept whereby we allow you to use certain copyrighted materials irregardless of the fact that the authors own it. And to give you an example, did any of you watch The Daily Show or any of you watch the news at night? And they play clips of various things. Well, somebody owns that material. Do you think that they pay for every news story, or the Comedy Central pays for every act of satire based upon a speech that a president makes? even though somebody owns that copyright? The answer is no, and the reason is fair use, and I'll get into that next time. We'll cover it quickly, and I'll tell you, I think maybe next time I'll tell you the story of graphene. I'm constantly wanting to make this meaningful to material science students, and the story of graphene is just really cool, and I'll tell you all about it. It's a fun way of illustrating these concepts. So I'll see you Tuesday, hopefully, all right? And don't forget to eat. Thanks for coming. Any questions?